Today I'd like to talk to you about the best tips to deliver your deposition testimony and nail your deposition. Your case, like any commodity, has a value, and my job is to make sure that we could get the highest and best price for that commodity. The way we do it is to package it well. In order to package it well, there are certain rules that we have to follow. Let me just give you an example. If I buy two identical shirts and I put one shirt in a Saks Fifth Avenue box and dress it up Saks Fifth Avenue style, and I put the exact same shirt in a JCPenney box and dress it up, the box that is, in JCPenney style, my guess is you would pay more for the box that comes from Saks Fifth Avenue than you'd pay for the JCPenney box. Well, your case is no different. An insurance company is going to pay more for the case that's packaged well than they would for a case that is not packaged well. So the first order of business is to talk about the standards that apply to you giving deposition testimony. First of all, you have to dress appropriately. For a man, that means dress slacks or casual slacks, maybe even khaki slacks, and a long sleeve shirt. Do not, under any circumstances, come to a deposition in short pants and a Hawaiian shirt or a tank top shirt. That is a surefire way for the defense lawyer to eyeball you and take one look at that attire and decide he's not paying a lot of money for your case. However, if you come dressed in a suit or in casual slacks with a long sleeve shirt, then he is going to think you're going to make a better appearance in front of the jury, and he's going to value your case more. In terms of a lady, you've got more room for error. Ladies can overdress, and that is a major sin in a deposition or even going to a courtroom to deliver testimony. If you overdress, one conclusion would be you don't need the money because you're dressed so well. The other conclusion is that it's kind of tacky if you come to a deposition dressed in a cocktail dress. My suggestion is you come to a deposition as a woman dressed in either a suit or just slacks and a long sleeve blouse. Do not overdo the jewelry, don't overdo the makeup, and don't overdo your hair. Come with a conservative look. Insurance company adjusters are going to pay more money for your case if you look appropriately and dress appropriate. Also, for women, do not show any skin. Dresses or blouses that have spaghetti straps on them are just not appropriate for a deposition or for court. That's not a way to impress the other side. Typically, the defense attorneys are looking for a conservative look, and they're willing to pay more money for a conservative look. So bear that in mind before you attend your deposition. And of course, you should talk to your attorney before you attend any deposition. The next tip for delivering great deposition testimony and nailing that deposition is, by all means, sit down with your lawyer and go over the facts of your case. Be prepared. Know the date of the accident, the time of the accident, maybe even the day of the week that accident occurred. Also, be familiar with the road conditions, the weather conditions. Know the year, make, and model of the car you were driving. Know the makes of the other cars that were involved in this accident as best you can. In addition, be familiar with the lane in which you were traveling before the accident. Be familiar also with the distance away from the collision you were when you first saw the other car. Be aware of the relative distance when you first braked before the other car struck you or before you struck the other car. Be familiar with traffic signals, such as red lights and green lights and stop signs and yield signs. Be familiar with whether the roadway had a shoulder on it, didn't have a shoulder on it. Know at least the direction you were traveling in, north, south, east, and west. In New Orleans, we have particular ways that we deal with direction, and only if you're from New Orleans would you understand that. But we'll say upriver, downriver, riverbound direction, lakebound direction, and I'm sure every area from every parish or county has a similar way to describe directions that they're traveling in. You have to be familiar with that in order to deliver good, positive deposition testimony. As an additional preparation, you have to read the police report. Go over that police report with your attorney. You don't have to memorize the narrative of the police report or all the specifics in the police report, but generally have a working knowledge of what's contained in that police report so that you're acquainted with all of the facts, the scene, and so forth, the witnesses' names, so that you can make identifications of people when you're being asked questions during the course of that deposition. You want to have a working knowledge of this so that you can look as a very well prepared deponent during your deposition. Be familiar with your medical records, review your medical records, review your bill, have a working knowledge of your bill. You don't have to remember each and every date that you went to see the doctor. Sometimes you may have gone to a doctor 30 or 40 times, so you're not going to remember every date, but what you might remember is that you went to the doctor maybe 30 or 40 times. That's appropriate to testify in that manner. If you don't remember something, it's appropriate to say you don't remember. That's okay. So be familiar with your medical records, the relative cost, the relative number of times you went, the types of doctors you sought treatment from, whether it's a chiropractor, a general practitioner, or a specialist of some sort, like a neurosurgeon or an orthopedist. Now, with respect to your medical treatment, you should know the parts of your body that were injured in the accident. The best way I talk to my clients about remembering that information is just start from the top of your head and work your way down your body to the tips of your toes. So if you had a head injury, then start there and then move your way down to your neck injury, your left arm injury, right arm injury, wrist injury, torso, chest, those types of things, and work your way down your body in describing those injuries. Remember how long it took for each one of those injuries to improve, and be able to describe the types of pain you were in for all of those types of injuries. For example, if you had shooting pain down your arm, then say you had shooting pain down your arm. Don't say I had an injury to my arm and describe it as a whole arm injury. It may not have really been a whole arm injury. It could have been pain shooting down the back of your arm. Describe that, because that's going to become important. Once again, you're showing the other side how well prepared you are. And if you don't do it, your attorney should do it for you. You and your attorney should go over each and every one of your injuries so that you are the best prepared witness. If you have stabbing pain, then describe it as stabbing pain. Sometimes I've had clients say it felt like a nail was being driven in the back of my neck. So describe it that way. Describe it as tingling, but use descriptive words so the other side, the defense lawyer, can understand, and more importantly, if this deposition is ever used in front of a jury, more importantly, the jury will understand the type of pain you are describing, because oftentimes they themselves may have had that type of pain as well. Also, be familiar with your work history. That's important because they're going to ask you questions about each and every job that you held over the last 10 or 15 years. They're also going to ask you how much time you missed from work and maybe what the value of that time was. Like what were you paid on an hourly basis at the time of the accident? You should know that information. And if you don't know it, talk to your attorney about it. He or she probably has that information and can review that with you. Now, as another tip for your deposition, the absolute gold standard, I tell this to all my clients, is tell the truth. That's the most important thing you can deliver, because that's going to give you credibility. If you are caught in a lie, a fib, or however you want to frame it, if it's not truthful, it's going to come out, you will be exposed, and guess what? Your case will suffer. The value of your case will drop down, and it will drop from maybe a Saks Fifth Avenue package to way below a J.C. Penney package. And that's the problem with not telling the truth. You have to remember that the other side, in all likelihood, has information about you that you don't know they have. Remember, you're giving up your Social Security number to the other side in the course of discovery. They then run that Social Security number with insurance companies, and they have a whole history of accidents that you've had in the past. So be truthful about your history of accidents. Be truthful about your history of medical conditions, because easily the other side's going to get your pharmaceutical records, and they're going to see that you had Oxycontin prescribed 6 years ago, and they're going to find out exactly why you had that Oxycontin prescribed to you. So again, gold standard, tell the truth. I or any of us who are in the personal injury field as attorneys, we know how to work through that so that it would be less damaging to your case. But you have to be truthful. You have to tell me first, and then we can maybe massage it in such a way that it won't be as damaging for you. But if you're caught in a lie, that torpedoes your case. Do not guess at an answer. You know, sometimes when there's a conversation going on and there is a lull in the conversation and no one's saying anything, there is a need sometimes for you who is being asked questions, who's being interrogated, to fill that void or that lull with noise. And that noise is oftentimes the wrong answer. You're going to talk too much because you're afraid of that void and you want to fill that void. Do not get baited into that. Do not guess at an answer, and do not fill that void with information that could be harmful to your case. Additionally, do not, under any circumstances, volunteer information. You know, the old adage about someone asking you what time it is and then you tell them how the watch is made and you never really ever tell them what time it is. Well, don't get baited into that. When a question is asked, you have to listen to the question and answer that question and only that question. Once you start volunteering information, bad things happen. Do not volunteer information. Something else that I often see in depositions, and this is a great tip, don't exaggerate your injuries. I've had people at depositions that say they can't stand upright, and then of course after they deliver that testimony, the defense lawyers show me films of you standing upright, maybe picking up a child, maybe picking up a grandchild, maybe going on the roof of your house, cleaning your gutters, when you just testified in a deposition that you've never done that since the accident, but before you used to do it. I can guarantee they're going to have film on you doing the very thing that you lied about saying you couldn't do. They've got you doing it. So don't exaggerate. If you've got a back injury, look, don't say that you can't have sex with your wife or your girlfriend because you have a back injury. That is almost preposterous, because the human urge to have sex is rarely prohibitive because of a back injury. Rarely. You're going to find a way to have sex, so don't fib about it. You can say, I have trouble having sex. I have trouble climbing on the roof to clean the gutters. I still do it, but I'm in pain 3 weeks after I do it. That's a better way to deliver your testimony. But don't exaggerate your injuries to the point where it's almost ridiculous. Once again, you've got to package your testimony well so that you seem and are believable, that you have credibility and integrity. That's going to give your case a bigger and better value. I hope these tips have been helpful to you, and if you do and should have an accident, please contact me, Cliff Cardone, at the Cardone Law Firm. We have offices in New Orleans, Baton Rouge, and Lafayette.